Hello, everyone. Welcome back to the LAOT Podcast. I'm Arnav Mathur, and today we are going to talk about something that touches every courtroom and every lawyer in India. The question of whether artificial intelligence is changing what it means to practice law and deliver justice. The framing of this conversation is extremely relevant. Indian courts carry a pendency of over 5 crore cases in total. The Supreme Court had more than 87,000 matters pending as of May 2025. The judiciary has responded with tools like Supe, Suvas, and Terries. These are AI systems dedicated for case research, translation, and transcription. And simultaneously, there's also a generation of legal tech startups that have begun building tools that sit directly in the workforce and the workflows of lawyers and judges. Now, to think through all of this, we are joined by Ms. Anya Batra. Anya is the co-founder and chief operating officer of Jhana AI, India's first AI paralegal. Jhana was founded at Harvard in 2022 and is built around a national legal archive of 16 million judgments and statutes. The platform is already in use by more than 10,000 users, including 150 judges and registrars across 5 courts. Anya, thank you so much for being here today.
Yeah, no, thanks for having me.
All right, so let me start with talking about the problem before we move on to the solution. Most of our listeners, I assume, would be familiar with how overburdened the Indian courts are. But I want to make it more concrete and real. You work directly with courts. When you walk into a district court or a high court registry, what does actual dysfunction look like on ground? And where do you think AI can step in and help?
Yeah, I think I've increasingly started thinking of the judiciary more like a national public health system, where most health outcomes are not determined inside this operating theater, but they're determined by triage, diagnosis, and patient records. Um, and I think like the courts are very similar in that sense. What tends to happen is that judges spend this extraordinary amount of cognitive energy sort of reconstructing context, reading badly organized notes, tracking procedural history. I think AI's biggest contribution here could be giving the justice system something that's closer to longitudinal memory and this diagnostic infrastructure. What I sort of mean by that, and sort of doubling down on the pendency problem that you spoke about, right? And this is a number that like we're often plagued with. And I think I was reading Daksh's report, the 2025 tribunal report, which talks about how about like 0.5% of our GDP is just trapped in these commercial suits. I think the number was something like 24 lakh crore, which is like 7% of last year's GDP, just like stuck. And what I mean by stuck is this is frozen money where you cannot, like frozen credit, where now you can't sort of move business, you can't like grow this money. There's no sort of interest that it can be interest it can accrue, etc. So I think judicial delay is not just a rights-based problem, but it's also a very real balance sheet and economic growth problem in India. Um, now, like where Jana sort of comes in into this system is, uh, I think things that are really deeply unsexy, like say, for example, the registry, right? Now,
Yeah.
those are parts of the system that when you walk into it, you realize that judicial efficiencies at inefficiencies at every stage. And that's not adjudication. Judges are passing orders faster than they're actually being passed today. And
Yeah.
cases are not delayed because judges are slow, contrary to sort of the 21 judges per million to about recommendation of 50 judges to a million that was made. I think they're delayed because, of course, litigation strategy, defective filings take almost a month to get back to an advocate.
Yeah.
Cause lists are set at inconveniences of parties, therefore they're not able to make dates. Substitution of advocates triggers a de facto restart to a case. And these sort of contribute to delays. in a very basic and like almost a clerical way, where you have things like numbering, stamping, return of defects, and
Yeah,
not judicial time that's being lost here. Um, so I think like the way we sort of have framed this problem is that it's it's a political economy problem, obviously.
yeah,
Um, uh, but where I think we want to really like come in and sort of be these partners with the judiciary is at three levels.
yeah,
One is this administrative pain that's felt. So things like filing scrutiny, defect detection, numbering, cause list preparation, all of this is clerical and can happen using technology. What this looks like for the litigant is that now, and we were having this conversation with one of the judges in the Karnataka High Court, and sort of were telling us that now with scrutiny, somebody who is languishing in jail because their bail matter is not being heard because their uh, file is under process by the registry can now be heard instantaneously because you're getting your scrutiny response in about 15 minutes.
yeah,
Now, sort of extending this out of the registry itself, and with some courts, we're having this conversation of what does this look like for the advocate. Now, if the
mm,
advocate is able to sort of pass their file through scrutiny as like almost a pre-scrutiny check,
yeah,
a file that's problematic won't even enter the system clog, right? It's like
mm,
solved at the advocate level and only then coming into defect detection. So these are sort of the places where we can start.
mm,
And I think like the registry is the most clogged part of the thing, and I think
yeah.
it's the unglamorous part that's not judgment writing that AI can do, where you'll really see like the most impact.
Uh, Very nice. I understand like the problems, and you've mentioned about how it's not just limiting the justice delivery system, but also the GDP and national economy as a whole. And that framing, I think, is quite important. And
Yeah,
I mean, there's
and
an yeah,
just also tying back to that health metaphor, right? Like
yeah,
the Indian court is like this tertiary hospital which has no triage system, no
mm,
patient chart, no lab integration. Like there's no concept of this medical record, which is an EMR, which I can now maintain my entire patient history on, right?
yeah,
Every time
yeah,
something comes, we directly send them to the surgeon. And then we
mm,
blame the surgeon for the waiting room. So,
yeah,
and India has no shortage of brilliant legal surgeons. I think
absolutely.
it's the primary healthcare system that's not really there in terms of like, so
Yeah,
I just sort of drawing back to the legal primary healthcare system, right? And I think that's a way in which like also given where India is with like technological adoption and how like
mm,
slow the courts tend to be, maybe this is an advantage for AI because there's almost like this institutional plasticity that allows us to rethink of what that process is.
yeah,
Maybe I'll give you a small operational example with some courts where we have started implementing scrutiny.
mhm,
It used to be maybe like a 23-point checklist for which the advocate would have to sort of enter their case. And only once that's sort of been met, the file is admitted.
yeah,
We can now bring that 23 item checklist to maybe about like 10 or 5
mm,
because a lot of those things can be corrected on spot. So, for
yeah,
example, um, like a page numbering defect now
yeah,
can be corrected by AI on that spot, and that becomes the true numbering, and therefore the judge and the party that gets the file back has that sort of as a continuity, and that becomes the final record through which the court can now build a top. Not only is it having a memory of that case, but also of the advocate and the litigant. So yeah, I think it's about building this like institutional memory infra for the legal
yeah.
system.
And I mean, the inefficiencies start from the ground up, so it only makes sense to resolve them and use AI deployment from the ground up itself.
Yeah, yeah. I think like scrutiny workflow has moved up. We've seen roughly from 1.5 hours to about 15 minutes with
Mm,
a higher average defect identification with some of the benchmarks that we've conducted than manual review. And
yeah,
it's the whole idea is that okay, like where will this currently fit into my workflow and who is accountable if this fails? The system that we've built actually accounts for that, and it's built around the operator. So now the registry staff is not somebody who's populating the checklist, but is verifying the checklist. And
yeah.
sort of you become a verifier and not a generator.
Hmm. Understood. I want to continue with this conversation about AI and the judiciary. I mean, this is a very obvious case of AI helping the scrutiny process and managing a docket very well. So that I think no one has an issue with, and I think that should have seen widespread adoption as well. But there's a harder version of this particular problem that I want to discuss, which is that when you start integrating artificial intelligence even in a purely assistive role, at what point do you think that it starts shaping the judgment itself? If the AI tool surfaces certain precedents or summarizes the pleadings in a certain way, then at what point do we see that the judge's discretion is now being overtaken by the AI or being shaped by the AI in some way or the other? How
Yeah.
does that phenomenon work?
Yeah. Yeah. Now that's a great question. I'll just sort of highlight what we do as Jhana, and we've sort of have refrained from like judicial core functioning. What we try to do is more of this legal researcher aid to the judge,
Yeah.
and sort of have built this around deep neutrality guardrails, where everything that's sort of pulled out is audited back, cited back, and again with sort of deep uh, emphasis on the fact that it's entirely neutral and constantly citing, okay, this has been drawn from this part of the docket. But
Mhm.
that's a great question, and I'll tell you why. Because even as an editor, a good editor can actually shape what that outcome looks like.
Yeah.
And I think even if you think of how like Google changed journalism, right?
Yeah.
Editors didn't replace writers, but then the attention economy that Google created
Mhm.
restructured what stories got written, read, and valued.
Yeah.
And the tools can sort of shape an ecosystem without letting anyone even choose to decide to do that.
Mhm.
Similarly, right? And like this is again not a unique problem to law, where even with AI assisted diagnostic tools,
Yeah.
you sort of reading CT scans, the concern was that will AI replace the radiologist? And the answer was that no, that radiologists who are systemically using AI are now shifting their attention to parts of the scan that AI is flagging.
Mhm.
And of course, on the flip side, inadvertently, there were maybe pathologies that were in the unflagged zone that the and it redirected where the sort of um, operator was looking, uh, not really replacing but narrowing, and this is obviously very very concerning.
Yeah.
The way I like to personally think of it is this sort of threefold test, and I'm very uh, akin to the legal world to sort of think about this, right? Is that you have to have like these three things. Two of them I would say are like technological problems, and one of them is maybe like a legal challenge, which is like I would apply this fold test, which is first traceability. You have to have the judge or the operator have that auditability to see where exactly this proposition has come from, and that's something we've also like taken into cognizance while building any tool out for the judiciary or lawyers for that matter.
Yeah.
The second is completeness.
Mhm.
Can the tool show what it considered, what it didn't consider, what is the least what or sort of at least the limits of the corpus that it's looking at slash
Mhm.
whatever it's searching through. uh, Even for this, again, I call this a technological problem because what we have built Jhana atop is our
Yeah.
proprietary sort of ontology model, which gives you this completeness guarantee, where it doesn't use maybe a traditional RAG based approach, but
Mhm.
uses this formal verifier that builds out a graph and then traverses through each node in that graph to actually go through every single point. In a way, if you think about it, and I used to sort of work on the judicial side. In the Supreme Court as well, where we would get such large volumes of cases where it's really impossible for everyone to go through every page in a
Yeah.
way that the now AI is able to do that.
Yeah.
So the first was traceability, the second was completeness, and the third I think is contestability,
Mhm.
where you should always have that sort of um, ability where a council can challenge something. And
Yeah.
again, this is more of a legal sort of thing that the court can maybe create and sort of re-envision what that legal side would look like if there's fear of like machine shaped summary
Mhm.
or citation set, right? And I think that if you are going to embrace these technologies, then it has to come with some sort of safeguards. And this is a fairly good sort of way to approach it, because like ultimately it's now that the judge is coming into a space that's completely prepared for them, where they have notes and they have like ability to like look at each issue and like trace that back to what the council has said. um And again, like these are things that, like if a judge is trying to do this ad hoc or like with the help of an LR who also could make a mistake or
Yeah,
like could also highlight things that are not completely sort of traceable or like that doesn't have that source exposure. I think technology actually gives you the visibility and like allows you to do that in a better way.
understood. And I think these threefold test, of course, traceability, completeness, and contestability, I think gives a broad framework of how uh, ethical, I would say, I would use the word ethical use of AI in the legal field would look like.
Yeah.
But I want to shift towards a more philosophical question now, which is that of cognitive atrophy. There's research not just in the legal field, but in different fields like aviation that shows when professionals rely on heavily automated systems over a sustained period of time, their ability to perform the underlying task unassisted degrades. And I mean, from like a personal example, if I'm using, let's say, AI to write an email, after a certain period of time, even if I try to write an email on my own, I would rely on AI to do it in a better way itself. If we try to apply the same logic to the legal AI field, if you're now training a generation of judges and a generation of lawyers from on these research tools which summarize from the outset, what happens to the skills that have no AI substitute? And how do you build that particular skill set in the future?
Yeah. Obviously, I think the risk is extremely real, and I think this is again industry across for white collar work where intelligence is going to be really really cheap, and then what is the value add that a human has there? And then the question is that intelligence? And of course, this is its own philosophical question of what is the value of human labor slash intellect in sort of these spaces where you have, well, like it's intelligence on tap, right? Um, I think like of course aviation is a great space to sort of make comparisons. I think when it was like, I think it was the 737 Maxes when they came out, pilots who used sort of heavy autopilot to retain their instrument scanning skills, and then like the mechanical substrate of flying uh sort of improved overall, but their cognitive skills deteriorated. I think, like, of course, there are parts of this that I can sort of transpose back to the legal ecosystem, right? And
Hmm.
I think my sort of advice, or like the way at least I like to think of it, is that there are parts of good atrophy and parts that are bad atrophy. Like, I think it's okay to have the dependence on like clerical drudgery. For example, like if I don't remember so like in law school, you're meant to remember what the book says and sort of
Yeah.
like wrote that back there. And I think like that's a part of this good atrophy where I would say it's still okay too. But I think the problem is also that you may lose the ability to evaluate what the legal truth is.
Yes.
So I think like some atrophy is not bad. I think uh, there is obviously like some level of preservation of manual labor. I think what that role looks like will change, right? Now, what I was
Hmm.
saying with the registry staff is that they are not generators of this information anymore. They are verifiers of it. So I
Yeah.
would think of like looking at the evolving role of what that person actually needs to do. So even with the flights, it's maybe like situational awareness is something that the is there's a premium on that, and not so much knowing exactly where things are in that system because of how
Hmm.
automated it is. So I think it's definitely like I don't know how you develop deeper in instincts. So for example, if an authority feels misread or when a summary has flattened the ratio, these are hard things to do when you're going just based on completely sort of relying on these tools blindly. But if you use it like a sparring tool, and I think like
Yeah.
a lot of people have started sort of entering that space or substrate of being able to like challenge, question, use it like this tool that's um, use it like basically like a sparring tool, question it and
Yeah.
sort of ask it to give you like detailed sort of responses to things or why it's thinking about certain things and like questioning that.
Hmm.
I think you definitely have much greater access to being able to have deeper learnings in a way that you wouldn't have had before. Um, yeah, and I think like this is something that's plagued every industry in the sense as even when you look at um taxi drivers in London. I think there was this article that I was reading, which they basically did this study, I think with 25,000 taxi drivers, where they saw that drivers that don't use GPS actually develop this capacity to remember the roads a lot better,
Yeah.
and sort of has a potential increasing risk, or sorry, decreasing risk for Alzheimer's type spatial disorientation, whereas like increased hippocampus sizes,
Yeah.
etc. I don't know what that world looks like, but I think like the way we think of what our role is changes.
Yeah.
So and I think if like systems are constructed around that, where like for a law student, right? Like
Hmm.
if you are now like writing an email is not valuable because that's super
Yeah.
templatized and I don't write emails. My agent runs my inbox and also writes all my
Hmm.
emails. The value is in something else and there'll be a premium on that.
Understood. And I think you've mentioned these three broad points that I think are important. First is that not all atrophy is bad. If you have to think about, like, we have to think about a society of what we value in terms of atrophy. And the second is that you think of AI not as just some person who's doing your job, but as a tool with which you can counter and possibly deepen your learning as well. And of course, the broad overarching third point is that we, because of AI and because of these technological developments, the baseline of human expectation increases. You start rethinking about what you value from humans and where that input is going to be.
Yeah.
So I think it's pretty interesting, and
Like
I
what happens in I'm sorry to interrupt, but in Silicon Valley, right? Like now where founders run these solo one-person company where I just have multiple agents running my marketing team, running my sales, my CRM, running my finance.
hmm,
The real premium there is not finding the person who's the best at marketing, but is now becomes okay, like do I have that kind of I don't want to say taste because that's a very subjective word, but do I have that sort of ability to pick out and like have that judgment of okay, this should fly, but this should not go ahead because now
yeah,
the AI is going to give me 17 versions of it and I have to pick out what the best one is.
hmm,
And that will really sort of, I mean, there's this word that's loosely thrown around in the Valley, which is high taste founder.
hmm,
And sort of you can see that it's like what your natural sort of taste towards a certain thing is sort of
yeah.
reflected in the work that you do.
Understood. And I think training would play an important part in how we adopt AI. And
Yeah.
specifically within the Indian courts, there was this incident in February of 2026 where the Supreme Court addressed the growing problem of AI generated fake citations in judgments. There was a trial court judge in Andhra Pradesh who relied on four fictitious judgments and generated by an AI tool, which she claimed that she was using for the first time. And the court went on to say that we could classify this as judicial misconduct. So the stakes are very high in these sort of situations. How do you diagnose this incident? Uh, what's the role of training, not just
Yeah.
the clerical staff, but also the judges and the lawyers in adoption of AI?
Yeah. Uh, Sort of like these are going to be like problems, growing pains that we have till the point AI gets so good where like hallucination is not a thing. I mean, again, right? This is a feature, not a bug in different industries where it's able to like think creatively and sort of pull these out. But obviously, when you work in the legal space, it is sort of I think for the court to come out and say and classify this as like misconduct is constitutionally very, very significant. But I think it's operationally slightly backwards, and I'll tell you why. Because punishing the user for a tool failure is like treating the symptom and not the disease.
Yeah.
It's like we don't sanction pilots for autopilot malfunctions, right? We certify the autopilot and we say that okay, these are vendors that can now come in, and these are spaces that you can now sort of use this technology that has sort of regulated past whatever benchmark that we wanted to. And I
Yeah.
think the correct response here is mandatory certification of legal AI tools before they can be used in certain court proceedings, right? I think like whatever accreditation system that the courts think or deem necessary, similar to what the EU AI Act does for really high risk AI in the administration of justice. India doesn't have this yet. And I think that until it does, punishing individual judges is a deterrent strategy and simply drive AI use underground than actually making it safer, right? And I think it's almost like a systemic failure, if I may say so. And so, for example, this trial court judge who claimed that they were using AI for the first time, there's
Yeah.
no protocol for verification, there's no institutional guidance, there's no peer culture of like discussing AI outputs, right? In medicine, if a new diagnostic tool comes out,
Mm.
it goes through ethics committees, trial clinics, protocol integration before a doctor actually uses it
Yeah.
unsupervised on a patient. And I think legal AI being adopted by the judiciary in that sort of way without any equivalent professional infrastructure
Mm.
could be problematic. And therefore, like when we sort of onboard high court judges, the first thing that we sort of notice is that the judges are extremely cautious users.
Mm.
They ask really hard questions about how it works, and sort of credulous about the output once they accept the tool.
Yeah.
And I think like the court as an institutional signals authority.
Mm.
So I think it's both an institutional and almost like a failure of the system, if I may say so,
Mm.
that things like this happen, where I think like it's like you have to sort of come in with the idea that okay, people are going to use it, and if they are going to use it, I might as well use something that's safe, has
Yeah.
citations, audits it back. If it doesn't have an audit trail, I should not look at it. And then sort of that training is where it'll really stand out. um, yeah, I think it's like a citation first architecture is not a feature,
Yeah.
but that's the entire point, and that's sort of what we've also tried to build out with respect to the judiciary and legal system.
Understood. I think having a framework and some sort of an institutional guidelines or training is
Yeah,
extremely important because it's no longer a question of if judiciary or the legal system will adopt AI. It's just a matter of when. And you already have cases of almost everyone across the legal spectrum, everyone's using AI to some extent or not. So having a framework of how to effectively use AI and having these trainings, I think, is really important.
yeah. I mean,
And
the answer is not to ban it at any
yeah,
point of time, right? It's like to ban the unverifiable use from legal reliance.
mm,
And I think the court has sort of made some endeavors to sort of figure out what that looks like.
yeah,
But I think there's always going to be and I have my own sort of reservation on this, but there'll always be a tussle between what that public-private question looks like. And,
mm,
just a small sort of like off like an example that we've seen, right? There are like users and the stakeholders in the system that are already using like and because I talk to them every day, some of them use off the shelf tools like maybe like a Google Lens and using personal email IDs. And I'm saying people are already using it now. You might as well sort of let them use it in a much more safe way where you have somebody responsible, whether that's a private vendor like us or whether that's
mm,
some kind of other provider that they've chosen to interface with.
yeah.
But yeah.
And on this public-private discussion, the Supreme Court itself has invested a lot in their own tools. They've got Supace, I think, for case research, Suvas for translation into 19 Indian languages, and Theories for real-time transcription. Now, these are institutions that are building for themselves. From a business point of view, how does this interact with a player like Jhana or any private legal AI tech company, for that example? Is the
Yeah.
relationship between these institutionally made tools and privately made tools competitive, collaborative? How does that work?
No, that's such a great question, actually. I think the relationship will always be complementary. That
Mm.
means if courts are building the rails, private companies come in and build accountable engines that run on these court-approved tracks.
Yeah.
And I think that it becomes competitive only if public tools try to do every workflow end to end, or
Mm.
private tools become unaccountable for the shadow infrastructure. So, like an example of this, right, with some of the courts that we work in, where they host their DMS on a state data center, and they already have sort of like some kind of format through which there's a cause list that's being prepared and circulated, and the files come in and so on. So
Yeah.
the idea is that you want to build atop this. You want to come in and sort of, again, exactly like the uh, railway example, right? Where like
Mm.
you have this basic infra coming in, and then you're like building atop that in a way that's a lot more safe and secure. And I think the worst outcome that could come out of this is that courts crowd out startups. And,
Mm.
like when you have outcomes that like if the court is a massive institution, right? There are
Yeah.
different parts of it, and like if each part of or each department of the court tries to build out something in its own sort of department or workstation, it may create like these silos. So
Yeah.
actually, when we come in, when we sort of talk to courts initially, we try and do almost like the stakeholder consulting process where we
Mm.
understand what the process is. The idea is also not just to slap on an AI there just so a broken system sort of continues these like moves really fast as a broken system, right?
Yeah.
You want to see what are places that you can really think of and like restructure that judicial process or legal process. One such great example is the sort of reconfiguring what the scrutiny checklist should look like, because now
Mm.
with AI you can correct a lot of these things on spot without it actually going back to the advocate. Like for
Yeah.
a page numbering defect, right? It's insane that it goes back and there's a 15-minute delay, 15-day delay for it to come back, and
Mm.
sort of creating this like really operational inefficiency.
Mm.
So like definitely, I think like I think the UPI example is great, where like
Mm.
India's strongest digital system is not a pure state monopoly or a private monopoly. I think there are protocols with which allows you to have this ecosystem that brings out innovation and sort of new companies that allow you to build atop that. And legal AI needs the same architecture, which is like
Mm.
court owned standards, and atop that whatever applications. I think
Yeah.
courts should be extremely fierce about like certain things, right? Like governance standards, data
Mm.
access rules, security and audit requirements. um, but private companies can come in and sort of do like faster workflow, faster iteration on specialized
Mm.
workflows, domain specific models,
Yeah.
integration layers. And see, it's also like had the privilege of meeting a lot of judges, and I think that these are ultimate adjudicators on very, very different types of subjects, and they really
Mm.
do understand the technology space.
Yeah.
But frankly, to do procurement of tech, you have in private companies, you have consultants who come in and you actually have them do like benchmarks and analyze and sort of understand what the best tech procurement is for a particular
Yeah.
type of workflow or institution or whatever role, team, company. And that doesn't exist in the court, right? And you can't expect a
It's
judge to also
yeah.
sort of pass this sort of procurement order, but also do the most deeply complex tax problem, and also at the same time passing some kind of a note on building toilets in the court, right? These are very different things, and I think having that kind of professional, maybe it's some like IAS role that's created there
Mm.
to sort of evaluate these on their own merits, and that way you can have the best technology coming in
Yeah.
um, to these public systems.
Understood. And I think this complementary system is important because the baseline will be set by the courts, but the actual effectuation of it can and should come through private players because they have the resources and the ability to achieve such a thing.
Exactly.
Yeah.
Exactly. And I think like when you have this, so if the basic infrastructure, right? And like
Mm.
some courts are even reconsidering what they want to do as their basic infra. Do they want to have like a state-based data center managed DMS, or do they want to build something of their own? The courts have incredible autonomy based on each state to do what they want, because there's been no sort of central effort to procure that top down, right? And I
Mm.
think like so each court is basically writing their own grammar, and like
Yeah.
ecosystems should be allowed to write sentences within this rule set that they make. But I think what's what's really like important is that once you have this interoperable layer across like different courts and public infra systems, and we're a while away from that, it
Yeah.
really changes the way different ecosystems interact with each other. So, for example, if a head note is being passed today, it has to be communicated to the relevant prison authority, social welfare
Yeah.
organization, whatever it is, right? Like if a judgment is passed. Now, once you have written the judgment, the court's duty sort of ends there. That
Yeah.
communication, that transmission. Now, those are places also where like private in players can come in and sort of build that plumbing out for the courts.
Yeah.
Where you now have like this global system of record. And India's done really, really well with this on like administrative things, right? Like if you think of all the things that have come out of the India stack,
Yeah.
like some really great, like both financial digital systems, but also administrative. And I think legal could get there at some point.
Understood. And I think one important point that I think gets overlooked a lot of times is that when you're looking at legal AI, it's not just the courts or the lawyers, it's also the entire justice delivery system. To have an head note pass from the court to the prison authorities, for that entire chain is something that can be integrated with AI. So
Exactly, exactly.
yeah, and now I think I want to talk more about the lawyers, which is that as a field, the lawyers in India are extremely stratified. There's a tier of elite law firms. There are certain people in the middle of the solo practicing field. And one of the arguments, which is the most common argument, is that AI will democratize the field in certain senses, where now even someone who's working just from on their own have more resources to use these AI tools and get into the market. But the counter that I could think of was that, practitioners at certain stages would not be able to afford these cutting edge AI tools. And just simply because of the subscription fees, they may lack reliable internet, which is a reality across many parts of India. They might not have the training, which is something that we discussed. Where do you think is this access gap between, you know, democratizing
Mhm.
the legal field and AI adoption?
Yeah, I think there is always a missing middle problem where, and I think this happens, uh, like AI is slated or like thought to maybe exacerbate that, where
Yeah,
it's like elite lawyers become super lawyers first. Lawyers who can't really afford this um, sort of have moved to like maybe some off the shelf tool that's free, but that's also maybe training on their data or
yeah,
whatever that sort of model looks like. Like maybe I want to start with one thing and then like take this conversation somewhere else and what that looks like for justice delivery and not as a lawyer problem, right?
yeah,
Uh, to be very honest, AI, I think the biggest resource constraint in AI today is that it's an expensive technology.
yeah,
I think there is like massive effort to try and bring this down, and like we work with public institutions, and we're extremely mindful of like how this has to be beneficial beyond that. It's almost becoming like money saving tool and not really something that's just expensive for the sake of being expensive, right?
yeah,
So we also sort of have uh, moved from like how do you make this accessible to people, but the way I have lately been thinking about it, especially after having with the coach so extensively, is that uh, maybe for rights or like economy, like rights based problems like the law in developing countries, so things like health and law is
mhm,
something that the state can actually pay for. And I think that when you think of justice delivery, there are parts of the system where for example, the Ministry of Law has created these systems, like its telelaw scheme, or it's
yeah,
I mean the courts have NALSA and try and whatever it is to sort of reach these dense region, these rurally dense regions, and give them this aid and support, right? And the problem is not whether like like earlier the problem would have been that there is a certain, like, this is creating accessibility, but there's also a capacity problem where, like, I can only help you as how good my lawyer in that particular district or that particular rural area is. Whereas now with AI, I think you'll have a capacity expansion, where now you're not only just able to become that access point to intake, but you're also maybe able to do like some kind of relief and triaging and then escalation with AI, in sort of increasing the ability of that operator in that particular system to do more for the distressed person here. So, um, in a way, like, if I look at the problem here as justice delivery, I
Yeah.
think now you will be able to reach a lot more people, because you'll suddenly increase the capacity of all these like rural CSCs that have, like, I think last year Telelaw did about like 12 million cases, right? Where instead of just doing something really simple of like, okay, if you have a legal problem, you come to me, you give me your problem, and I'll triage it to somebody else or send it to a relevant authority. Now you have made that travel and come all the way to me. I can actually dispense some kind of legal solutioning for you.
Hmm.
And that's the way I've been trying to think of this problem, uh, where it's not just, it's not a software model that needs to be democratized, but it's a service model that needs to be democratized. And I think the state will definitely have to play a bigger role. And
Yeah.
this won't just come from like private institutions, where like obviously private institutions can like augment and improve these processes, but ultimately the state, I mean, the state has a lot of money. It's also the largest litigant, right? Like,
Yeah.
one in every $6 spent today by the state
Yeah.
is a legal dollar, and like either used in state litigation or like some other form.
Yeah.
So I think there are like creative ways to finance this that doesn't really come for um that sort of doesn't really like have to be through like private sector companies making their products completely free, because it's also like at the end of the day, right, like when something is free, there is somebody that's paying for it, and it's
Yeah.
either you or your data, or like some other
Yeah.
sort of interesting way that you are being captured there. So
Yeah.
it's something worth thinking about from that perspective.
Understood.
But
And I think,
yeah, and sort of, I know your question was about lawyers and
yeah.
sort of went all over the place. And I think that what I meant by it's not like a software model, but it's actually a service model that'll change. Now,
Hmm.
think about this, right? Where like maybe an elite lawyer has something like a Westlaw subscription, whereas now, whether this looks like maybe a WhatsApp chatbot in like some 14 languages telling a daily wage worker in UP whether their employer's deduction is legal under
Hmm.
the Payment of Wages Act. I think the industry is almost uniformly building for lawyers in that sense,
Yeah.
where now you actually have access to it directly through the principle of this problem, which is maybe that sort of daily wage worker, or it could be like the agent, the lawyer who's translating it for them.
Understood. No, I think it makes sense to think about the conversation in like multiple strands. The first strand is that you look at AI not just as a uh, as just as a service and not just a product or a platform. And then you also look at if democratization is the value that we are for in terms of the legal field, then someone like the state has to enter at some point to make sure that this platform gets more downstream and
Yeah.
has more
And
penetration across
and in
multiple.
fact, Arnav, honestly, I'll push back with the question itself, right? Like, think about today. Like, you, of course, go to a very premium institute, which is Nalsar, where they give you access to maybe a Manu or an SEC or whatever it is, right?
Yeah.
Most lawyers who are independently practicing don't have access to these legal databases and sources, right? Like, they're also just like to scramble off of like what they get on the internet. And at that point in time, I'm like, if like AI becomes a like if AI is sort of that differentiator for it, I think that there are much bigger problems to sort of solve here, as opposed to somebody getting access to faster research and drafting. I mean, heck, I don't have access to like Indian Kanun is my best alternative to this, right? Which is
Yeah.
like, again, not one of those sort of mandated providers, which is like the court that now explicitly relies on like SCC.
Yeah. Understood. So I'll just close with
So
this one.
maybe
Yeah.
just a recommendation suggestion there is, right? This data and sort of generally judicial data should be the onus of. Firstly, I believe that all judicial data to most extent is public data because it's
Yeah.
individuals who are filing cases there. Legislative data is a whole other argument, but courts should take the onus to actually put that data out there in a way that's accessible to people. And yes, of course, people will say that, like today as a litigant or today as somebody who's filing a case in the Karnataka High Court, how will I find out where my case is? Because I don't have access to what my advocate has filed.
Mm.
There's no sort of visibility or access to that. So instead of like really coming to private players and sort of having this system or conversation of like, okay, where can we consolidate this data and put this out in a database? The courts should do it. And in fact,
Correct.
that's the best way to do it.
Yeah.
Today, it's against like 100 ways for me. I have to struggle to actually get to see what my advocate has filed. But if
Mm.
the court has like this unique litigant ID along with an advocate ID, I can easily sort of have visibility on that.
Yeah. And I mean, transparency then becomes an actual value and not just a buzzword that's used
Yeah.
in our delivery system. Okay. There's just one last question that I wanted to ask you overall, which is that you mentioned about the EU model where they have a specific AI Act and it classifies administration of justice as a high risk and has mandatory transparency and human oversight requirements. We don't have a specific AI law as of now. Where do you think the overall regulatory trajectory could look like, specifically for legal AI as well?
Mm-hmm. Right. Uh, Honestly, like I know I did cite the EU AI Act. I have my own reservations on that as well.
Yeah.
I think a word, and we throw this around in our organization, is security theater,
Hmm.
which is sort of this sort of big sort of optical illusion that we must do of like how we are doing the most and sort of protecting it without actually getting the system. I'm like, before we get that, let's actually get the system and let's actually give and dispense justice a lot faster to the people
Hmm.
who need it, right? And like it's sort of my like contrarian take for the EU Act is that India's reluctance to adopt some framework like this is often critiqued as regulatory backward, but I think there might be like a genuine competitive advantage where I think there is a compliance architecture that imposes these enormous costs on AI companies, which slows down innovation, right?
Yeah.
And in high risk domains like the judiciary, it may actually prevent the use of such tools. So
Correct.
while I'm not sure what the exact sort of way to tread this path is, but there seems to be like a reasonable case of like a permissionless innovation until something actually is there.
Yeah.
Obviously the fake citation scandal being exhibit A,
Yeah.
but it's also allowed Jhana to build this out in a regulatory environment
Hmm.
where an EU style legal tech company would still be figuring out what the conformity assessment is.
Correct.
So I think the question is moving towards like these targeted outcome based regulations without getting into this compliance overhead of the EU framework.
Hmm.
Like, yes, I think uh, like in 2026, India has no equivalent. The closest that we come to is maybe the DPDPA,
Yeah.
which again is not like standalone AI. It's sort of we've just been put into one bucket
Yeah.
because it just sort of happened at a time and space where that was sort of important to speak of. But I think like I think when we're in a country like India where you're actually trying to advance innovation and do it fast and do it in a way that's really useful, you don't want something as detailed or as sort of um, like something as robust as like an EU style AI Act, but maybe something similar, which is like an intermediate, like a guideline path where like maybe I think the Supreme Court already is endeavoring to like have these discussions and conversations where like I think
Hmm.
it's important to involve all stakeholders, right?
Yeah.
Including potential like vendors and consultants, where even we come in and we tell you like what the best way to deploy this is, right?
Hmm.
Like we are extremely flexible in the way we deploy because we allow like the courts to tell us what and how to deploy in a way that makes the most sense for them, right? Like one such
Yeah.
example is whether they want to do like a managed cloud or an on-prem
Hmm.
solution. In fact, I was sitting down with somebody at the Métis and we were telling them that we want to do like a complete on-prem solutioning, and he said that like obviously like having uh, a local model running there where like
Hmm.
you have it completely, maybe even have an offline system, also has its own resources, right? You need to have, like, if you have a GPU in a court, you need the infrastructure to maintain that GPU. And
Mm.
the question is, are we as a country in that point in space in time where we want to spend this on like infra, or like are we okay to maybe start as like a managed cloud space, obviously completely data local and resident in India,
Yeah,
but maybe start there, and then eventually we want to move on to like larger sort of infra conversations. But I think like these are again conversations that we have been having. I think we're all very, very early in the game to sort of
yeah,
realize what the best way to do this. I mean, like, these are professional companies that actually do cloud, and if we're able to sort of meet the criteria to be in India, then maybe that's the better way to do it.
yeah.
As a company, and this is sort of my personal view, but as a company, we want to give courts that customizability and flexibility to deploy in a way that they deem fit.
Yeah, understood. And I mean, this just goes back to the Porter hypothesis, which is that there's a sweet spot between innovation and regulation. If you
Yeah,
do, if you have regulation way before innovation, then it ends up stifling it. And if you have
exactly.
regulation way after innovation, then you're not able to control the output itself. So, I mean,
Yeah.
I think in terms of India, I think we should focus more on innovation more than just a standalone compliance-based regulation. And I think that model would is seem to be working in India as well. So
Yeah. And I think like India's advantage is that the courts actually move fast. And I think we don't have to wait for this grand AI Act, because the courts have like great level of autonomy where if they
yeah,
decide that something is needed, then you come on, you build that on out for them. But again, I think like, and this is not so much as like an EU AI Act, but like more of a procurement guidance to courts, where like each court doesn't have to independently figure out, okay, what the best model is, what the best system is. If the MATI has several impaneled vendors like that, if the judiciary also does something like that, then
mm,
makes procurement more streamlined for everybody.
yeah,
Um,
looks sounds good. Thank you so much for taking out the time to be here and to really allow me to pick your brains through all these complex issues. It was a pleasure talking to
Thank you so much for having me, Arnav.
you.